Assalamu alaikum and welcome back to Just Law on IQRA TV. I'm your host Ilyas Bulbulia and this is the second part to the show. Just before our break we were looking at how we can make a successful spouse application, looking at some of the pitfalls and also looking at some of the ways that we can try and ensure that we avoid common problems and the application is successful. As our viewers are aware, it's a live show. The number that you can call on should be appearing at the bottom of the screen. So please do pick up your phone and do give us a ring if you've got any questions that we can assist you with. Now, just before the break, I'd got up to one of the sort of key areas where spouse applications are made, that being ensuring that the financial aspect of the rules are met. And I was looking at wage slips and bank statements and how we need to ensure that we do things properly. But before we go into that, let's take our next call. Hello, assalamu alaikum.
Hello, assalamu alaikum, brother Ilyas.
Ji walaikum salam. Ji bhai, jazakallah. Thank you for calling.
Brother, I'm Mahmood speaking from Glasgow.
Ji bhai, ji.
You've been dealing with my case.
I remember. Yes.
Yeah, so brother, actually, obviously, as you know, that will go 5 years visa again.
Ji.
I'm going to get ILR. So can I apply on my son basis? He's going to be in 6 months' time, 7 years old.
Yes.
Can I apply on his base?
You see, in your case, I think the difficulty with a lot of people in your situation is that they just changed the rules in December 2016. They changed the rules, and a lot of people were then caught out with the fact that they then required the UK British citizen to having worked in the previous 5 years, which was never the rule before. But in my experience, where people have been granted a residence card for 5 years, it's normally easier to get indefinite leave if the British citizen here in the United Kingdom then continues working for the next 5 years. Because the problem is, if you switch visas, whichever visa that you go into, you have to start again from year zero in most of the visas. So if you, for example, make an application based on your child, which is fine, you can do that, but then you have to meet the 5 year, the requirement where you apply under 5 year, the partner route, is that 5 years have to be spent under the 5 year partner route. So if you switch now, you have to do another 5 years. And I think the cost is a problem, because if you switch now, you have to pay for switching. They grant you a 2.5 year visa. So at the 2.5 year stage, you have to apply again for the extension. And then at the completion of the 5 years, you have to pay in order to obtain indefinite leave. So the problem is, if you switch now to the immigration rules, you can do that. But if you do that, the cost is quite significant. And you don't have an advantage simply because you have to complete 5 years. You're better off in your situation where you have a European residence card just to complete 5 years under the visa that you have at the moment under the European rules. Now, it's just unfortunate that a lot of people got caught out because the rules were changed. And the Home Office position is that we don't care if the rules have changed. We will simply apply the law as it is at the date of the decision. It's very unfair, but what can you do? It's what's happened is, over the years, European rules have been tightened, and this was one of the things that they did in order to make it more difficult for people who'd lived abroad come back to the UK with their British partners, using the Surinder Singh route to come back. This is one of the things that they did to make it more difficult for them to qualify for indefinite leave. But I think in your case, and I think in most cases where somebody has been granted a residence card, they're better off staying within that visa.
So, but I already spent 5 years, and will spend again the next more 5 years.
Yes, that's the thing there. You have to spend another 5 years in the United Kingdom, or we could track it back to, because the point they're making now is that the British citizen who didn't have to work before under the Surinder Singh route, when they come back, we can count the 5 years from the time the British citizen starts working. So if the British citizen has been working for 2 years, we can count the 2 years. If it's 1 year, we can count the 1 year. And then we have to complete the remainder of the time in order to get a total of 5 years of where the British citizen has been working. That's the key point at the moment. That's the new the amendment that was made. That was the amendment, that the citizen has to have worked for 5 years, which wasn't the case before. So we need to show 5 years of employment, self-employment for the British citizen in the UK. It doesn't matter if you don't work. It's the British citizen that now needs to work for a full 5 years.
But you mean you shouldn't apply on my son basis?
No, there's no point there, because the amount of money you've got to pay, and it doesn't help you because you end up you don't get indefinite leave. This is the problem now. What you then do is you start again. There is a category, it's called a 5-year partner route. So you come in within the immigration rules, but again, you have to complete 5 years under that. So I can't see a real benefit in doing that. You are allowed to do it. There's no problem. You're allowed to do it. But I can't see a benefit because it still takes you 5 years under the new route. And under the Surinder Singh route, from when your partner, the British citizen, started working, I think you've completed a year and a half already under that. So you've got another 3.5 years to do. You just need to ensure that you keep records of the self-employment of your partner or the employment of your partner. If you're self-employed, the partner is self-employed, there will be accounts, there will be tax returns which are being submitted on a yearly basis.
Yeah, she's already doing that.
Yeah, so what you'll have to do at the end of the 5 years of her being self-employed, 5 years accounts, 5 years of tax returns, 5 years of that self-assessment document that you get, that is then sufficient. It's unfair, but it looks like even the courts are saying the Home Office is entitled to change the law, move the goalposts effectively. And the point is you have to meet it at the time the decision is made. So we're stuck with these ever-changing rules that they're introducing in order to make it more difficult. But we're stuck. But in your case, from my recollection, you just need to complete, as long as your wife completes 5 years of self-employment, it will be fine at that stage.
Right.
Okay, so thank you.
Okay, brother.
Jazakallah, thank you very much for your call. Just on that point, especially with European applications, what has been happening is that the law has been tightened, amended as time has passed in order to try and discourage people from taking advantage of European rules. And the problem always is that it's not the law when you entered a particular scheme that counts. For example, you marry a European national, the law that applies at the time won't necessarily be the law that will apply when you apply for indefinite leave. And indeed, it's not even the law which is applicable at the time of your application. The courts say it's the law as it applies at the time of your decision which is applicable. So, you just need to be careful that you do meet the requirements as at the date of the decision. And if you get caught out, hopefully there's another way of remaining in the United Kingdom legally. Now, just going back to what we were talking about, the issue about wage slips and bank statements. The key point is that whatever the wage slip says in terms of net pay, that's the money that needs to be going into your bank account. Certainly where the payment is being made by cheque or the payment is being made by back transfer directly into the bank account, the amount has to match. Now, there's slightly more flexibility when it comes to cash payments that are being made to the sponsor, and the sponsor then takes the money and deposits the money into the bank account. There, what the Home Office is saying is that, look, if the amount matches, fair enough, we'll accept whatever the gross amount is on your salary, we'll say that's your salary. But if it doesn't match, we will only count the money that's gone into your bank account and consider that to be your income. So they accept that where somebody receives cash payments, there may be a discrepancy between the amount that they receive and the amount that they deposit. But the key point is, if there is a discrepancy, they will only count the amount of money that's gone into the bank account. And that in itself may cause problems, because it may mean that you don't earn enough because you haven't been, they will only count the money that's gone into your account, so you don't earn enough. Secondly, we go back to the original problem, which is that if the money doesn't go in accordance with what's on the wage slips, the difficulty is that the Home Office may well say, we don't believe you're working, your wage slips and your bank statements don't match up, which is the key problem with spouse applications nowadays. But that's the second key document. You've got your wage slips and your bank statements. The third document in relation to employment should normally be the easiest document to get together, which is just simply a letter from your employer, a current up-to-date letter which is no more than 28 days old, which confirms your employment. Now, even here, unfortunately, there are problems. So I'll look at those in greater detail after we've taken our next call. Hello, Assalamu alaikum. Hello.
Assalamu alaikum.
Ji, walaikum salam. Ji, thank you for calling. Ji, what's your question?
मेरा क्वेश्चन है कि इस तरह I have a limited company.
Right, okay.
And my wife is employed in my company.
I understand, yeah.
Is she will be considered as a self-employed or?
You will be considered, she will be considered as a, well, when you submit the documents, even if you rely just on her documents, because it's the company that you own, what will happen is that she will need to submit documents for the whole year of the limited company. So whatever the financial year of the limited company is, generally speaking, they're the documents that will need to be submitted. Now I suspect when she applies for an extension or indefinite leave, you will rely on your income and her income as well, I suspect. Is that what you're going to do?
Yeah, because I am employee of somebody else's company, but she is employee of my company.
Okay. Does she own any shares in your company?
No, she's not.
Is she a director?
She's not director. She's not secretary, just employee.
Okay, all right, okay. If she's not a director and has no shares, I think she may be that she only needs to submit 6 months bank statements. But what I would do is I would look at the up-to-date rules as at the time you apply, because this is an area where they wanted to tighten it. What the rules, from my recollections, currently say is that if you're a director of the company and the shares are held by family members, that's when you need to submit 12 months of wage slips and 12 months of bank statements and then documents relating to the limited company. I think where she's not a director, I don't think that obligation applies.
Because I even though I own the company, I work for somebody else.
I understand, right.
And she's employee of my company, and me and my friend are director of my company. Basically, we two directors.
I understand. Okay, all right. But then I think what you're going to be able to get away with is 6 months wage slips and 6 months bank statements. As far as I can recollect, because she's not a director of the company, the obligation to submit 12 months bank statements, 12 months wage slips and limited company documents don't apply to her because she isn't a director of the company. I think the obligation only kicks in if she's a director of the company. And that's my recollection. Now, what I'll do is on the next show, I will double check that and I will clarify that when we go through it.
I have one more question, sorry. On the application it's saying, because my all children are British, so in the application it's saying, is any of children will be in the application, and there's one question like...
I need children included in the application. Because they are not applying, they are not dependents who are applying. They may still ask you who they are, but they are not dependents who are applying. So as you go through the form, I think it's very early on in the form, I think it's section 2, are there any dependents applying with you? So you will say no to that. But there will be another section where they will ask about your children generally. They're not part of the application, but they're asking about your children. So at that stage, you will have to provide all the details for the children, although they're not part of the application. But it just makes it easy for them to assess whether the relationship is genuine or not. That's the purpose behind the application, behind that information that they're requesting. Okay, brilliant. Thank you.
Thanks.
Thank you very much for your call. So basically, just going back to where we'd got to in terms of financial documents that need to be submitted. We've got the wage slips, we've got the bank statements, and the third key document that we need to submit is the employment letter. Even on the employment letter, there are certain specific requirements which need to be met. For example, the letter cannot be more than 28 days old as at the time the application is made. So it's an up-to-date letter that needs to be submitted. Now, the other requirements are more important. For example, the letter needs to confirm, generally speaking, 5 things: that you are employed by the company, the capacity in which you are employed, the date on which you commenced employment, how much you earn, how long you've been earning that amount of money, and what type of employment you're in, whether it's fixed term, permanent, etc. Out of all those 5 or 6 requirements that need to be set out in the employment letter, the most important piece of information that the Home Office is looking at is your earnings. What does the employer say about your earnings, and how long have you been earning that amount of money that you are relying on? So where you have a salary, and it's a fixed salary, what the Home Office is looking at is that, have you been receiving this fixed salary for a period of 6 months? That's the reason for requiring wage slips. That's the reason for requiring this information to be included in the employment letter. So if we take, for example, somebody's earning £15,000 a year, we get to a stage where they're about to submit a spouse application for their husband or wife, and they up the income to £18,000 a year, and they get 1 or 2 wage slips which shows that they are on, let's say, 18,600. It's not sufficient that they've been on that level of earnings for 2 months, 3 months. They need to be on that level of earnings for a minimum period of 6 months. And that's why in the letter it's been asked, what is your current salary? How long have you been on that salary? Because if you've been on it for less than 6 months, it's not sufficient. So normally it would say, the current salary is X amount, and this is the date from which the sponsor started receiving the amount of money he or she claims to be on. So even where you've got a very basic application comprising of 6 months employment, and the documents are fairly straightforward because they're 6 months wage slip, 6 months bank statements, and an employment letter, even then there are areas where you could go wrong. For example, if you look at the common reasons why these applications are refused, it may well be that the documents which are submitted are not up to date, so they're more than 28 days old. It may be the length of the period over which the documents need to cover, that's not covered. The employment letter may not contain the required information. You've submitted copies instead of original documents. It may be that you've submitted printouts of your wage slips, but the letter from your employer doesn't confirm that the wage slips are genuine. It could be that there's a discrepancy between what the wage slip says in terms of net pay and the amount of money that's going into the account. Now, these are all problems which should be avoidable. And all that it requires is looking at the rules properly and ensuring that the correct documents are submitted, they're up to date, the correct information is there. And that's why if you feel that you're not able to do it yourself, you're better off going to somebody who specializes in this area of law, who can look at all this and pick out the problems straight away and iron these common problems out and ensure that an application is made which succeeds the first time around. So that's the financial documents. And before I look at the different types of documents that need to be submitted for different types of income, we're talking about self-employment before, we're talking about rental income, cash savings before we go on to that, let me just look at what happens once you submit the required documents. Now, I'm assuming that the required documents have been submitted properly and they are all in order. Now, in my experience, in about 30-40% of cases, what will happen is that the employer and the sponsor will normally receive a telephone call from the Home Office, because the Home Office isn't just simply prepared to accept the information which is there on the documents. They normally want to investigate it. So they might do their own internal investigations. They might check with HMRC that these documents are accurate and correct, taxes, etc. are being paid. In addition to that, they may say, well, right, let's have a telephone conversation with the sponsor and with the employer. So they normally have preset questions that they have, and they ask the sponsor about their employment, they ask the employer about the employment. The reason behind it is to test what's being said. And in my experience, telephone calls are normally received where the Home Office feels that the work is being carried out in a small business where they believe that there's a bigger risk of inflated wage slips being submitted, or where people don't work, they simply obtain wage slips and they've submitted wage slips where the employment is fake. So with the smaller employers, you're more likely to receive a phone call. Even where you receive the phone call, in my experience, you should both be prepared in terms of the sponsor and the employer. They should both be prepared for a phone call. Now, and part of the preparation of the spouse application that's been made should involve ensuring that once the application is submitted within the next few weeks, when the call is received from the Home Office, that both you, the sponsor, and the employer, you're both ready to answer questions. So the questions are normally fairly straightforward. They could relate to the hours that you work, the hourly pay, whether you get paid monthly or weekly, when you get your wage slips, whether the money goes directly into your bank account or not, when you started the employment, how did you get the job, were you interviewed, was there an application form that was completed, did you have to hand your CV in, why is it that you got the job over somebody else, what skills and experience do you have which qualifies you for that post, when do you work, do you work on weekends, when's the last time you came into work, do you have a lunch break, who are your colleagues, who do you work with, what are your duties, explain in detail what your duties are, who do you report to, and then other questions which shouldn't really pose a problem, such as the environment in which you work, whether the place where you work, whereabouts is it located, how many floors are there within the office block, etc. What do you do for your lunch break? If you drive, where do you park your car, etc. But the key thing here is that it's not enough just simply to get your documents right and hope, well, my documents look right, I'm earning my 18,600, fantastic, that should be sufficient. That's not normally enough. You should be prepared to receive, you as the sponsor should be prepared to receive a phone call from the Home Office, and the employer should be alerted to the fact that they will receive a phone call as well. Now the reality is, when you receive the phone call, you could be busy at work, the employer is busy at work as well. Key thing is, when you receive the call, you do take it and you do give proper attention to what you're being asked and the answers that you need to provide. And in my experience, where the documents are fine and there's a refusal on finances, it's because the answers that have been given by the sponsor and the employer are inaccurate or lacking in some detail. We'll look at that in greater detail next week, but until then, Assalamu alaikum. That brings us to the end of the show.